Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, expressing disapproval of proceedings adopted by trial courts and high courts in cheating cases by which accused are directed to deposit the alleged cheated amount in court for granting bail, the Supreme Court has said that the criminal proceedings cannot be converted into process of recovery and courts cannot act as recovery agent. A bench of Justice S. Ravindra Bhatt and Justice Dipankar Datta quashed the order of Delhi High Court directing an accused in a cheating case to deposit Rs 22 lakh in court as a condition for anticipatory bail. It also held that courts should not impose harsh conditions to frustrate the very object of grant of anticipatory bail under Section 438 of the Code of Criminal Procedure and asked the High Court to decide the case afresh. The Supreme Court has stated its disagreement over a Punjab and Haryana High Court decision that handed down different jail terms to individuals convicted of the same offence. The case involved the conviction of 8 individuals for forming an unlawful assembly and fatally attacking a person with the deadly weapon. It noted that the convicted person had practically indistinguishable roles in the crime. Despite this, the High Court imposed a varying sentence on the defendants. The Supreme Court found the High Court's reasoning for the wide disparity to be inexplicable, if not outright bizarre, and observed that there was no consideration of individual roles played by the accused given the nature of the evidence. Consequently, the Supreme Court concluded that the High Court has erred in its approach and failed to assess the gravity of the offence. The imposition of a sentence undergone criteria without any indistinguishable feature in the roles played by each convict amounts to a flawed sentencing process, it observed. Next we have Delhi High Court. The Delhi High Court has observed that while causing someone's death is inherently wrong, using smothering and jack handle to inflict injuries may be considered extremely torturous, but it is not considered to be a particularly evil or shocking way of committing murder that would greatly disturb society's collective conscience. Therefore, it does not fall into the category of the most rare and extreme cases. The division bench of Justice Mukta Gupta and Justice Anish Dayal cited Supreme Court ruling in Shankar Kishan Rao Khade versus State of Maharashtra, wherein it was observed that when deciding whether to give a death sentence, the court must consider the crime, the criminal, and the RR test rather than a balancing test. In this case, the appellant kidnapped a child due to financial difficulties and ended up smothering and injuring the victim with the jack handle. While these actions were considered perverse, the case doesn't fall in the category of rarest of rare cases. The court also cited Manoj and others versus the state of Madhya Pradesh, wherein the Supreme Court framed guidelines for psychiatric and psychological evaluation of convict before awarding a death sentence. Answering as to whether a woman employee in the Government of India could invoke the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 if she was sexually harassed by an employee from a different department, the Delhi High Court has observed that there is absolutely nothing in the Act which limits its scope only to cases where a woman employee is sexually harassed by another employee working in her own office and accepts its application where the delinquent employee is employed elsewhere. The division judge bench of Justice C. Harishankar and Justice Manoj Jain allowed the citation of Shailesh Dhairaba versus Mohan Bali Krishna Lulla, wherein it was observed that the goal is to protect and support women's rights, including creating a safe workspace free from sexual harassment, and these objectives apply to everyone, are harasser neutral. The court had opined that gender equality is a constitutional requirement and that the working environment should be equally safe for both men and women. It further opined that the woman feeling unsafe in the workplace is not acceptable and goes against the principles of the Constitution. While it acknowledged the argument that the court cannot change or add to the law, it also suggested that if SHW Act does not protect women from harassment by employee of other organizations or departments, the court may have deferred to the law. It held that the SHW Act does not exempt men from being held accountable for sexually harassing women in different offices. Now let's have an overview of other high courts. The Orissa High Court has observed that it is a settled position of law that in the case of related or interested witnesses, the court must accept their evidence with some caution, and court should look into the independent corroboration of such evidence and the testimonies in the present case were independently corroborated by the medical evidence and other testimonies. The court upheld the order of the trial court which convicted the appellant under Section 302 and Section 307 of the IPC, and further observed that in a case based on direct evidence, the prosecution is not required to prove the motive of the crime, although that too was proved in the present case. The Madras High Court has expanded the interpretation of Article 17 of the Indian Constitution, which forbids untouchability in any form. Justice S.M. Subramanian made important remarks stating that untouchability encompasses not only caste-based discrimination but also practices of social ostracism and exclusion rooted in the ideas of purity, pollution and hierarchy. The court's verdict emphasizes that all practices resembling untouchability fall under the purview of Article 17 and are deemed unacceptable. The court's decision was prompted by a case involving the membership rules of the Madras Bar Association, which were challenged as the elitist and exclusionary. The court condemned the association's bylaws for enabling class discrimination and making it difficult for the ordinary lawyers to become members. As a result, the court issued an order mandating membership without any form of discrimination. The Bombay High Court has observed that the court can impose conditions including deposit of decreetal amount or part thereof in the event the court consider it appropriate to set aside the decree or execution and grant leave to the defendant to appear to defend the suit. However, such power to impose conditions cannot be exercised at the stage of registration, the notice of motion. The court noted that after passing a decree, Rule 4 of the Order 37 confirms discretion in the court to set aside the decree and if necessary stay or set aside the execution and grant leave to the defendant to appear to summon and to defend the suit under special circumstances and if seems reasonable to the court. The court is empowered to put the defendant to such terms as the court considers fit. The provision contained in Order 37 Rule 4 of the Code are distinct from the general power to set aside ex parte decree order under Order 9, Rule 13. The court stated that the defendant is required to satisfy the court that there are special circumstances which warrant the setting aside of the decree passed in the summary suit. The Calcutta High Court, while addressing a property dispute case involving a contentious question of whether a property transaction constituted a Benami transaction, has observed that in Indian society, when a husband provides the consideration money for purchasing property in his wife's name, it does not automatically indicate a Benami transaction. A division bench of Justice Tapabrata Chakrabarti and Justice Partha Sarthi stated that although the source of money holds significance, it is not the sole determining factor. The crucial aspect to establish in a Benami claim is the intention of the individual who supplied the consideration money, which becomes the vital fact to be proven by the party asserting the Benami transaction. Moving on to miscellaneous news. The All India Lawyers Association for Justice, in a letter written to the Bar Council of India and Bar Council of Delhi, has urged them to promptly take measures to ensure that all state bar councils reduce the enrollment fees to Rs 750 until the issue settles via a judicial order. The AILAG has stressed that the exorbitant enrollment fees charged by the various state bar councils act as a hurdle to students belonging to marginalized communities aspiring to enter the legal profession. A division bench of the Madras High Court has granted an interim stay on the July 22nd order of a single-judge bench directing the Madras Bar Association to distribute application for membership to all the interested practicing lawyers in the court. The single-judge bench had also directed the Madras Bar Association to admit them as members without discriminating on the basis of caste, gender, religion, political affiliation and economic status without referring to its bylaws. The Union Cabinet has cleared the proposed data protection law likely to be introduced for discussion during the monsoon session of Parliament, paving the way for the country's first privacy law under which data fiduciaries, government and private, will have to issue a notice to the public declaring the data collected, stored and shared by them officials familiar with the matter said. The law, however, will not apply retrospectively to any information breach that occurred in the past. The proposed legislation proposes sweeping changes in the country's data economy and is likely to be introduced in the monsoon session of Parliament. The Supreme Court of India has launched neutral citation system to implement uniform, reliable and secure methodology for identifying and citing judgments and orders. The system is being launched in a phased manner. Phase 1 shall cover the judgments and orders pronounced during the relevant time period of 1st January 2014 to 5th July 2023 and 6th July 2023 onwards. The judgments and orders shall bear a neutral citation number and quick response QR code on the top left corner of the first page of such judgment's order. The Supreme Court is set to examine the issue as to whether a partner's right to privacy can be breached for proving adultery allegations. A division bench comprising of Justice Krishna Murari and Justice Sanjay Kishan Kumar has issued notice in a petition by a husband challenging a Delhi High Court decision which had upheld the directions of a family court to take up his call details, records and details relating to hotel stay. The petitioner husband has contended that the decision of the family court infringes his fundamental right to privacy. It has further been contended that adultery is a private wrong and that in a civil matter such directions cannot be issued. In the end, we have international news. The US Supreme Court has handed President Joe Biden a painful defeat, blocking his plan to cancel $430 billion in student loan debt, a move that had been intended to benefit up to 43 million Americans and fulfill a campaign promise. The justices ruled against Biden's in a 6-3 decision favoring 6 conservative leading states and that object to the policy. The court's action dealt a blow to the 26 million US borrowers and applied for relief after Biden announced the plan in August 2022 and a political setback for the Democratic president. Same-sex couples in Nepal can now register their marriage after the Supreme Court has issued a temporary order clearing the way for gay marriage for the first time in the largely conservative country. The Supreme Court has been considering a petition on the issue filed by gay rights activists and issued an interim order allowing for same-sex couples to register their marriages pending a final verdict. Twitter has threatened to sue Meta over its Thread app, which Mark Zuckerberg has openly billed as a rival, claiming the company has violated Twitter's intellectual property rights. In a letter to the CEO Mark Zuckerberg, a lawyer for Twitter said that the company has serious concerns that Meta Platforms has engaged in systematic, willful and unlawful misappropriation of Twitter's trade secrets and other intellectual property. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for weekly updates, like and subscribe to our channel.